Go ahead and start. Go live.
We're live.
All right, good morning, everybody. This is the November 9th, 2023 Coastal Permit Administrator hearing. The Mendocino County Coastal Permit Administrator meetings will be conducted at 860 North Bush Street, Ukiah, California, and virtual attendance will be available via Zoom. Meetings are live streamed and available for viewing on the Mendocino County YouTube page. And with that, I'm going to go ahead and call the meeting to order at 11:04 a.m. May I please get a determination of noticing?
All matters on the agenda have been properly noticed.
Thank you. So what I'm going to do is take some items out of order. And we have 1, 2, 3, 4 items, and I'm going to go ahead and start us off with item 3B, which is case B 2023-0010. The owner applicant is Paul Rowson and E.A. Blake. The request is a boundary line adjustment to voluntarily merge two existing lots. Lot 1, APN 132-13005, being 0.79 acres, and Lot 2, Assessor's Parcel Number 132-150-27, being 0.3 plus or minus acres, will merge to become one lot at 1.17 acres total. The project has been determined to be categorically exempt from CEQA. It is located in the coastal zone 3.45 plus minus miles north of Manchester Community Center, lying on the east side of State Route 1, 0.26 plus minus miles east of its intersection with Pomo Lake Drive, and then 0.25 plus minus miles west of the intersection of Pomo Lake Drive and Forest View Road, in the Irish Beach subdivision located at 15721 and 15731 Forest View Road, Manchester, APNs 132-130-05 and 132-150-27. May I please get a staff report?
Thank you. Dirk Larson, Planning and Building Services. I have a brief presentation for you. As mentioned, this is located in the coastal zone. The subject lots are within the rural residential zoning district and designated as rural residential in the county general plan. This merger does not propose to create any new parcels, nor is it proposing any new development or change that would be inconsistent with these classifications. We referred this project out for review on June 16th and received no response or comments back from the responsible agencies. We also put this before the Mendocino County Subdivision Committee, and they identified no conflicts with the Division of Land Regulations and recommended approval to the Coastal Permit Administrator. This proposed merger, as you mentioned, is categorically exempt under Class 5A pursuant to the California Code of Regulations, Section 15305. Minor alteration in land use, and therefore no further environmental review was or is required. Staff finds this proposed project to be consistent with the goals and policies of the general plan, coastal element, and is recommending the Coastal Permit Administrator approve this coastal boundary line adjustment subject to the findings and conditions of approval contained in the staff report. That's all I got.
Is the applicant online?
I do not see him.
Dirk, do you recognize anybody?
Yes. Is it Paul?
Paul Doe. No, Paul's for.
Yeah, no, I don't see him. It's Paul Rowson.
Okay, if anybody is online for the item for boundary line adjustment B 2023-0010, owner applicant is Paul Rowson. Please raise your hand. Okay, seeing nobody. I'm going to go ahead and open the public hearing. Is there any members of the public that wish to speak on this matter? Seeing none, I'm going to return it back to the Coastal Permit Administrator. I And in consideration of the evidence provided, including the findings and conditions of approval, I will go ahead and approve boundary line adjustment 2023-001 pursuant to the conditions contained in the staff report as well as the findings. All right, that takes us to the next item, which is item 3C, case number CDP 2019-0002 and CDV 2019-0001. The owner applicant is Frank Abels. Agent is Paul Douglas. The request is a standard coastal development permit for the construction of a single-family residence with an attached garage, including a driveway and production well and sewer connection to the public sewer district. Coastal development variance for the single-family residence to have a 29-foot building height above average grade. The environmental determination for this project is a mitigated negative declaration. The project is located in the coastal zone, 0.2 plus minus miles east of Anchor Bay Town Center, on the east side of the intersection of Ocean View Drive and Ocean View Street, 0.2 plus minus miles east of its intersection with State Route 1, located at 46,785 Ocean View Drive in Gualala. Assessor's parcel number 144-036-07. May I please get a staff report?
CPA Gonzalez, and thank you for your time this morning. This is Planner Waldman for Mendocino County Planning and Building Services. And as stated, this standard coastal development permit is requesting to develop a vacant parcel with a single-family residence with an attached garage and ancillary development. The applicant is also asking for a variance to increase the average building height by 1 feet from the allowed 28-foot building height limit to 29-foot high average building height. The applicant's variance request is to allow the residential design and location to be constructed at its proposed location, simultaneously increasing the distance from the proposed development to the identified ESHA on site and by reducing the amount of ground disturbance. This project was originally applied for in 2019, and the owner and their agent have worked diligently to prepare a development plan with multiple design considerations to avoid and to be the least impacting to adjacent ESHA on site and to reduce the amount of ground disturbance. The residence would be located at the flattest part of the site, where the site is impacted by the presence of non-native and invasive species plants. The proposed development already minimizes its footprint to such an extent that a variance to the height requirements is requested. Sorry for the repetition. Is requested to allow for the proposed 29-foot height of the building. Moving the structure further away would necessitate moving the structure further away from the ESHAs on site would necessitate raising the building to a higher elevation of average building height, as well as increase the amount of grading that would be ground disturbance that would be required, and was found to not be a feasible option. The proposed permeable driveway is minimized in size and will be located to require the least amount of ground disturbance, as there is already an existing cut roadway on the property, probably due to when the site was created and when the well was drilled under a categorical exclusion from its past. The proposed development would be provided adequate utilities, access roads, drainage, and other necessary facilities The electrical services would be provided by a PG&E or public utility service. The permeable driveway improvements are proposed under the project. Construction to, or connections to sewer services is provided through Mendocino County Water Works District, and there is a letter granting approval for the proposed development, and a test well would be converted to a production well for the Division of Environmental Health Requirements. Drainage and other facilities, necessary facilities, have been considered in the project's design. The owner and the agent have conducted multiple design alternatives to reduce and eliminate potential impacts to ESHA and ground disturbance. No development shall be allowed in an ESHA unless the resource is identified and will not be significantly degraded by the proposed development. And there has been multiple alternatives designed, and there was no feasible, less environmentally damaging alternative, and all feasible mitigation measures were considered. Mitigation measures have been recommended to reduce the potential impacts from the proposed project, and as conditioned, the proposed development would not significantly degrade the resources identified. The proposed development of the single-family residence, driveway, garage, and ancillary development is a principally permitted use of the rural residential land use classification and is consistent with the intent of the rural residential classifications of Mendocino County's coastal element. The proposed development is also consistent with the proposed purpose and intent of the rural residential zoning district in the coastal zone, as well as other provisions as outlined in Division 2 of Title 22 of Mendocino County's code. This includes the development criteria for environmentally sensitive habitat areas, setbacks from property lines, lot coverage, with the exception of the building height. That's the variance request. There are special circumstances applicable to the property involving size, shape, topography, location, and the surroundings. And the subject site is uncharacteristically small for the prescribed land use classifications, about 0.4 acres in size, and as well as the limitations for the environmentally sensitive habitat areas on the site. The granting of the variance or an increased building height would not be materially detrimental to the public welfare or injurious to the property or improvements in such vicinity and the zone of the property, as there's been multiple variances approved throughout the adjacent subdivision at the Anchor Bay development adjacent to this parcel. The parcel is currently, as stated, it's currently subject to the coastal rural residential land use classifications and zoning district regulations. The proposed project is completed in compliance with the recommended conditions of approval, will not have any significant adverse impact on the environment within the median of the California Environmental Quality Act. An initial study and adoption of a mitigated negative declaration is recommended. Conditions 17 through 27 are recommended by staff to ensure compliance with the CEQA requirements for the mitigated negative declaration. Staff does recommend the project to have approval with those mitigated negative declarations, the mitigated measure as proposed in the staff report. Staff has not received any comments since its notice of intent was posted at the beginning of October, and I believe that the owner and the agent are both present, and staff is available should you have any questions, and that concludes my presentation for this project.
Thank you, Jesse. I'm looking at a couple of emails where they came from Douglas Hertine, dated Tuesday, October 17th, submitting the geotech report, and then there's also another email dated Tuesday, November 7th, Looks like it was date stamped November 8th. To you from Douglas Herting, says, Jesse, please review the attached edits to condition 17 and consider updating it. The language shown here from Mr. Herting says, 17, prior to issuance of any ground disturbance or building permit associated with the coastal development permit, the applicant shall obtain safe access via encroachment to the proposed development to the satisfaction of the State Department of Transportation, Caltrans in parentheses, including obtaining an encroachment permit for any work within state right-of-way consistent with the Caltrans pre-application review, project number 1MEN1-6.995 for the proposed driveway development to access the parcel. He's basically saying, to modify 17, and I am looking at condition 17. It's basically an avoidance measure with regards to ecological and botanical consulting. So can you please speak to the to what's being proposed here and where this condition would be applicable?
Yes, I can. Thank you. Those comments are for a project that is to be presented at the November 15th CPA hearing for a CDP number CDP 220001 for a Douglas Herting located on a property that is further south from this project.
So not applicable to this one.
This is not applicable.
Perfect. Okay, thank you. Just needed clarification because it was with this packet. All right. So with that said, I see do we have the applicant online for this?
Yes, we do.
So we have Frank Abels and Paul Douglas. Either one want to go first and speak on this matter? Does the applicant want to speak? Yes, Mr. Abels.
Okay, Paul, if you want to go ahead and start. Hopefully there.
Either one.
Well, Paul's representing me, so basically he knows the whole gist of this. I thought he was going to be online.
He's there.
He is there, but we hear nothing.
Paul, can you hear us? I don't know. I think he cannot hear us.
All right. Well, did you want to say anything, Mr. Abels?
Well, I just wanted to see where we're at on approval. I mean, it's been some time since we started this, and all of those, he has all the paperwork, all the data, all of the material regarding this, and he's basically the brains of the operation. So for him not to be there to be able to speak is going to, put us at a disadvantage here, I think. I don't know why he cannot hear us, why he can't respond.
Well, he's not muted, so he's in the chat, or he's in the call. Yes, he's raised his hand, so go ahead, Paul. Mr. Douglas, we cannot hear you.
Mr. Douglas, you may need to check your audio connection on Zoom. There should be an option to look to make sure that you're pulling from the microphone, or you should be able to call in on a telephone if your audio is not working on your computer.
Okay, it looks like he's left.
He's
Maybe trying to reconnect.
Yeah.
So do you have to go ahead and allow him to talk?
See if it'll work now.
All right, Mr. Douglas? I still get no audio. Yes, go ahead, Mr. Douglas. Your hand is raised, go ahead. Still cannot hear you.
Could also come back to this item, go on to the next one, allow him a
Yeah.
chance to call in.
So what I'm gonna do is I'm gonna go ahead and put this off to the side and bring this back so we can move on to the next item. And so what I'll do at this point is I'll go ahead and continue it for a few minutes and then bring you all back, and then we can continue the discussion. Because I've not opened the public hearing yet.
And if I may, Mr. Douglas, I would suggest there is a number on the meeting agenda that you can call into with a telephone, and I would suggest that might be the best approach here, so that way we will be able to hear your comments. There should be a telephone number and the Zoom ID that you will be able to join the meeting then.
So with that, let's go ahead and we'll move on to the next item, and then we'll come right back to this discussion. Okay, so we'll just put this off to the side, and we will go to item 3D, which is CDP 2022-0036. And the owner is Rona Pekic and Donna Vigil. Agent is Abby Colbert. Request is add a second PG&E underground electrical service with a new 100 amp meter to previously developed parcel. Services to power a gate used by 16 nearby parcels. This has been determined to be categorically exempt from CEQA. The project is located in the coastal zone 3.06 plus minus miles south of Fort Bragg City Center, lying on the west side of State Route 1, 0.39 plus minus miles southwest of its intersection with Ocean Drive, located at 34,250 Sunset Way, Fort Bragg. Assessor's parcel number 7017-0080-49. Now please get a staff report.
Yeah, thank you. Dirk Larson, Planning and Building. This project proposes underground electrical service or conduit to an existing entry gate or security gate to a 16-unit subdivision. The property in which this work will occur is on rural residential. And since this work is to occur largely below grade, it will have minimal impact to the residential uses in place and will be incidental to those uses. It is located in a highly scenic area, but since this is much of the majority work is occurring below grade, staff does not anticipate any visual impacts to the property or surrounding areas. It is consistent with the Mendocino County Code section 20.504. There were no ESHAs, environmentally sensitive habitat areas, identified on the project site or in close proximity. There was coastal prairie grassland identified, but however, the work is to occur within existing right-of-way, previously disturbed ground, which contains little to no vegetation. And this proposal will have no impact on any sensitive habitats or resources. It was referred out on February 1st, 2023 to Sonoma State University, at which time they concluded that although the vicinity may have sensitive archaeological resources, the proposed project had a very low possibility of containing any cultural resources. Therefore, no further study was recommended. So with that said, we did not refer this to the Archaeological Commission for review. As far as public access, the LCP mapping did not associate the project site with any proposed shoreline access or other minimum access locations. And this project site is not located on or directly adjacent to a designated access point trail or recreation area. It would not result in any intensive land uses increases and is consistent with Mendocino County Chapter 20.528. With that, staff is recommending the Coastal Permit Administrator, based on the findings and conditions contained in the staff report, approve this project.
Thank you. Do we have the applicant online?
I do not show him.
Do not show. All right. So I'm going to go ahead and open up the public hearing on this item on CDP 2022-0036. And are there any members of the public that wish to speak on this matter?
I do not see anybody.
And seeing none, I'll return it back to the Coastal Permit Administrator. So thank you very much for the staff report. I've reviewed the staff report, including the findings and recommended conditions, and all the evidence presented here, including the attachments and requests. And with that, I will go ahead and approve the project, subject to the findings contained in the staff report as well as the conditions of approval. Thank you very much. All right, so that brings us back to item 3C, which is CDP 2019-0002 and CDV 2019-0001. And this is for Frank Abels, and agent is Paul Douglas. So we just paused momentarily. So again, go ahead, Jesse.
Hi, Planner Waldman here. I was able to connect with Paul Douglas, and I have him on speakerphone, and he can hear and he can speak if we wanted to try that. He was having difficulty with connecting on his own device. So I have him on the line now.
Let's go ahead and have him speak on this matter. Mr. Douglas, go ahead.
Paul Douglas, can you hear me?
Yes, we can hear you.
Okay. I have been following your discussion, and I can give you some comments if you would like.
Go right ahead. I mean, this is the opportunity for the applicant and their agent to comment.
Okay. Mr. Abels is available, I think, online.
Mhm.
And as I communicated with Jesse Waldman, I have read and understood and we accept the conditions of approval as written in the staff report.
Okay, thank you. All right, do we have any members of the public that wish to speak on this matter? I'm opening up the public hearing on CDP 2019-002 and Coastal Development Variance 2019-0001. Any members of the public that wish to speak on this matter?
Sir, the only thing that needs to be done is the approval of the 1 foot increased height.
Right, I understand. So are you speaking as a member of the public on this?
Would you clarify that, Jesse?
Please hold for just a moment. I'm gonna mute it. Hold on just a moment.
I love creativity.
Yeah, I'm here. I'm with you. Okay. No further comments.
We'll come back.
Sounds good.
Okay, thank you.
So there are no comments. I see Jesse's nodding her head, yes.
Correct.
All right, so I'm just looking for, because I opened up the public hearing, I am looking to see if anybody from the public wishes to comment on this project. I see no hands raised, so I'm bringing it back to the Coastal Permit Administrator. And based on the evidence provided, including the mitigated negative declaration, the findings of fact, as well as the conditions of approval, I'm going to go ahead and approve the project subject to the findings contained in the staff report as well as the conditions contained in the staff report. So, Mr. Abels, your project is approved.
So where do we go from here?
I will let you, in fact, at this point, Jesse Waldman will reach out to you as far as the process goes. There is an appeal period. It's a 10-day appeal period and a coastal permit, a coastal commission appeal period as well. So Jesse can go ahead and discuss those with you. But after the appeal period is lapsed, then you can go ahead and move on to the next step, which will be the permitting process. So with that, this item is approved. Okay, so we'll take a moment to recess. I'm going to give this to you.
Sure.
And then we're going to go back to the first item on the agenda.
Okay, thank you.
Sure.
We're done there.
Huh? What?
We're just
Waiting
waiting
for
for
them
them
to come in. I muted it. It's up here.
I can still hear you.
Huh?
I can still hear you.
Do you want me to mute
Okay,
it?
we're gonna come on in, so.
I came by the other day and there was somebody on the roof, I thought it was you.
Oh, no, that's probably my husband.
We're gonna,
Oh.
okay, just allowing time.
Okay.
Yeah, so take a seat. I'll be on this side here.
How are you doing?
Good, how are you?
Good, good.
Good to see you.
Yeah. You look tanned. Thinking.
Tanned?
Yeah, he does look.
I haven't been anywhere. Must be the sun here in Ukiah compared to what's on the coast.
He's been vacationing, Donna.
Huh?
He's been vacationing.
I wish that was the case.
Yes, please, thank you.
Must be the fluorescent lighting that's doing it to me. All right, so we took a moment to pause to allow folks to come in. So we're now coming back to item 3A. And this is a continued item from September 14th. So let me just go ahead and reiterate here. The owner is William and Tona Mowers. The applicant is AT&T Mobility. Agent is Jared Kearsley. The request is a revocation of a boundary line adjustment to reconfigure two legal non-conforming parcels. Subsequently, a coastal development use permit will be processed to facilitate construction of a new cellular tower. Assessor's parcel number 132-21041. This is categorically exempt from CEQA. It is located in the coastal zone 3.2 plus minus miles north of Manchester, located 0.8 plus minus miles east of State Route 1. Site address to be assigned. Assessor's parcel number 132-21040 and 132-21041. Also, Project B is boundary line adjustment 2019-0054. The item, let's see here, was previously approved on 6/11/20. Owner applicant is William and Tona Moores. The request is a revocation of a boundary line adjustment to reconfigure the boundaries between three existing parcels and merge a fourth parcel, parcel 1. Assessor's parcel number 132-21037 will merge with parcel 3, APN 132-21039, and increase to 35 acres plus or minus. Parcel 2, 132-21038, will increase to 29 acres, and parcel 4, 132.210.61 will decrease to 16 plus minus acres. Again, this is categorically exempt, located in the coastal zone, 3.2 plus minus miles north of Manchester Town Center, located 0.8 miles east of State Route 1 on an unnamed access easement. Address is not yet assigned. Assessor's parcel number 132.210.37, 132.210.38, 132.210.39, and 132.210.61. And then before I move on, I'm just going to come back to the first item that I called out. I did not note the boundary line adjustment number, and that is 2018-0068. So with that, may I please get a staff report?
Sure. So this item, as you mentioned, is a continued item. And sorry, I should introduce myself, Julia Krog, Planning and Building Services Director. This is a continued item from the September 14th Coastal Permit Administrator hearing. At that time, the Coastal Permit Administrator continued this item to today's meeting. And this allowed staff time to respond to the September 13th, 2023 comment letter that was submitted by Mr. Colin Morrow, the attorney for the property owners. And that letter is attached to our memorandum dated November 8th. And staff did review the letter and provides response within the memorandum to the Coastal Permit Administrator. However, after review, staff has found that the comment letter did not provide any new evidence or facts that would modify staff's previously recommended action to the Coastal Permit Administrator. I can go through and go through the memo if you would like.
Yes, please.
And then I will end with recommended findings of facts that staff would like to bring forward. So there were several items raised in the comment letter. The first of which was that the county lacks the legal and factual foundation for revocation of the subject boundary line adjustments. As is detailed further in the memo, boundary line adjustments in the coastal zone are subject to both a coastal development permit as well as the review procedures in Title 17 of County Code, which relates to boundary line adjustments and divisions of land. And so the code section is cited in here where a standard coastal development permit pursuant to Mendocino County Code section 20.532015E is required for any development as defined in section 20.308035D, including but not limited to land divisions, lot line adjustments, and any other entitlement for use. So since this application was both a coastal development permit and boundary line adjustment for both B 2018-68 and B 2019-54, it is appropriate that the Coastal Permit Administrator, pursuant to section 20.536035, may consider revocation or modification for cause, including that the permit was obtained or extended by fraud. And that's detailed in section 20.536035A1 of County Code. The second item in the comment letter asserted that the permit application was not extended by fraud. Staff has attached to this memorandum the application forms, attachments B and C to the memo, which were submitted for the two noted boundary line adjustments, which were signed under an attestation that the applicant and owner's signature on the form certifies, quote, that the information submitted with this application is true and accurate. Since the submitted application for the boundary line adjustment, which can only occur between separate legal parcels, in effect, the signature was certifying that the parcels included in the adjustment were in fact separate legal parcels. Map attachments associated with those applications also further support that since they showed existing and proposed parcel configurations that they were being suggested as separate legal parcels. The comment letter also asserted that the property owner may not have been aware of, recalled, or understood the results of the prior court action from 2004. And staff really cannot attest to what may be aware of or recall or understand, but we believe that the property owner was knowledgeable of the results since they were the plaintiff in the case. The next item really speaks in the comment letter about vested rights and significant expenditure of time, money, and resources in reliance of county approvals. And I provided in the memorandum on page 2 a quoted section from the comment letter. And so in response to this, the memo speaks to a couple of court cases that relate to vested rights in terms of The first is saying an invalid permit vests no rights even if expenditures have been incurred in good faith reliance on that permit. And the second case states that no vested right when an agency is misled into issuing a permit by a developer. Then I'll speak to the improvements. I did a review of the timeline on development applications submitted or approved since the time of the boundary line adjustment approval, and that timeline is on page 2 and 3 of the memorandum. And in looking through those, it appears that most of the improvements relate to the establishment of water wells. It is not uncommon in our county to have multiple water wells on a single legal parcel, so staff does not believe that multiple parcels are required to drill multiple wells either. You are allowed to have multiple wells on a property within Mendocino County. The one area that was of concern to staff was this mention of a 30,000 gallon water storage tank, as we were unable to locate a record for a permit for that improvement, and typically those would require both a coastal development permit and a building permit. Again, it could predate Coastal Act requirements, so I can't say that it is unpermitted with absolute certainty. The letter also discussed debrushing activities, and while it wasn't really clearly indicated what it related to, I assume it related to the water storage tank or the permitted wells. And again, since staff didn't have more details, we were unsure whether or not it would qualify as major vegetation removal requiring a permit. And then staff provided, again, the timeline in the memorandum. And then finally, the comment letter alleged that revocation of the boundary line adjustments would constitute a taking of private property. It wasn't clearly stated how revocation of the boundary line adjustments would constitute either a physical or regulatory taking. So staff's only comment on this is that the Moores would still retain ownership of the lands. It's not being taken for any sort of public use. So the recommended action is that pursuant to Mendocino County Code Section 20.536035, staff recommends that the Coastal Permit Administrator revoke boundary line adjustments B 2018-68 and B 2019-54. Staff has prepared recommended findings of fact for the Coastal Permit Administrator to consider, and those are attachment D to this memorandum. I will not go through those line by line. It really is more speaking to how we got here, what the permits are that we are discussing, and the fact pattern leading up to today's hearing. And I'm available to answer any questions you may have.
Thank you very much. All right, so I'm going to go ahead and ask Mr. Morrow to speak on behalf of his clients.
Sure. Do I have a time limit I need to be watching?
I would say just, the time necessary. I just wouldn't take the whole day.
I appreciate that. I'll be succinct. I just want to make sure I wasn't up against a 3-minute clock there.
Everybody else will be up against the 3-minute clock. I defer to you, so.
And thank you very much for that. Before I get into some of the legal issues, I just want to say, generally as a resident of this county, I'm disappointed that time and resources and efforts are being spent on going back and picking what's really an unnecessary battle when this county has such budget shortfalls, when this county has such a lack of housing. And you have people like the Moores that want to develop more housing, more vacation homes in this county, that want what's best for this county and are seeking to benefit this county, and are instead being confronted with what seems to me like a war of choice from the county. Having more housing, having more vacation homes benefits everyone, and for staff to go back and reach years and years back into the archives to find something to second guess really aids no one, benefits no one. As to the legal points, I disagree that the Mendocino County Code permits any revocation of the boundary line adjustment at all, but I think that issue has been discussed. I do want to discuss these claims of a supposed fraud. Fraud's a very high allegation. A mere misrepresentation or misunderstanding is not fraud. Merely suggesting something to be a certain way is not fraud. Fraud is an affirmative and intentional, knowing representation that a material fact is other than how it actually is. I heard staff here use words like descriptive as to the Moore's conduct. I heard staff specifically say staff cannot attest as to the Moore's mental state in making any representations. As you yourself noted in reading off the application, AT&T played a significant role in this application, and it's not even necessarily clear that the Moores were the ones making any specific representations other than just signing off on the application. There is this one Court of Appeal decision from almost 20 years ago the Moores were involved in. But the Moores have been involved in dozens of lawsuits over the last 30 plus years. The Moores own hundreds of parcels of real property in this county. They don't know what every single word and every single legal opinion in every single case they've been involved in says or how those relate to specific parcels. Interpretations of what those cases say are not statements of fact, they're legal opinions. The Moores simply did not make any affirmative misrepresentation. There is no scienter, it's kind of the typical legal term of art. So there is no fraud. Something else that staff completely glossed over that was raised in the letter from before is the question of justifiable reliance. It's not a fraud where the listener should not have been misled by the statement. Staff planners are specialized in reviewing these kinds of applications. This is what their training is supposed to be about. Here, there's no indication whatsoever that the planner was in any way misled by any comments that were in any applications. It was the planner's job to go through and look at that stuff. If they didn't, they didn't, but that's not something the Moores can be charged with. In fact, Mr. Moores can testify today that planner Keith Grondike actually represented to Mr. Moores that he could boundary line adjust the parcels even further than he wanted to. If anything, Mr. Moores was relying on staff indications. I do want to briefly touch upon the Petit case and the related cases that staff touched upon. I had a chance to review those cases. Unfortunately, I only received this memo yesterday afternoon, so I haven't had a ton of time to really dig into it. But those cases specifically deal with instances where projects were inconsistent with the actual zoning of the parcels that were being developed. Here, there's no zoning inconsistency, and none of the cases pointed to speak beyond that. As to the issue of detrimental reliance investing, I want to make a couple points on that. One, staff's memo clearly spells out that the Moores have worked to develop those parcels since the boundary line adjustments occurred. These boundary line adjustments were approved June 13th, 2019 and June 11th, 2020. As staff's memo points out, multiple water permits were obtained and wells drilled since that time. It's also understandable that work is done to obtain permits, particularly in the coastal zone. So even though that's there, it's really only the tip of the iceberg. As to the takings issue, there's a few cases I would point out specifically to the Coastal Permit Administrator. Generally speaking, there's a long line of cases, and probably the most significant two to look at would be Penn Central and Lucas versus South Carolina Coastal Commission, which are both Supreme Court cases, which say that limiting a property owner's investment-backed expectations and how they're going to develop their property is a taking. A few California cases are on point, reaching back 70 years. Our Transocean Oil Corp v. City of Santa Barbara, it's a 1948 case at 85 Calap 2nd, 776, which states in part that a valid permit ripens into a vested property right which may not be taken from him against his will other than proceedings in eminent domain with payment of just compensation. There's similarly a case, Goat Hill Tavern versus City of Costa Mesa from 1992 at 6 Calap 4th, 1519, that noted that a tavern owner had a fundamental vested right to continue operating a tavern on property that could not otherwise support it. And then there's Avco Community Developers versus South Coast Regional Commissions, 1976 case at 17 Cal 3rd 785. It states that if a property owner has performed substantial work and incurred substantial liabilities in good faith reliance upon a permit issued by the government, he acquires a vested right to complete construction in accordance with the terms of the permit. I'd further note that under both California and federal law, where a taking has occurred, the condemning government body is on the hook for the property owner's attorney's fees. They're under Code of Civil Procedure 1036 in California or 42 USC 1983 under the federal statutes. And under recent changes in Supreme Court precedent, particularly the Township of Scott, Pennsylvania, the Moores would have a right to go straight to federal court to contest this, which is going to be an expense of hundreds of thousands of dollars to this county at a minimum. And it's an entirely unnecessary fight for a county that's already short on resources, that's already short on staff, that's already short on time. And there's just so many better ways for this county to be spending their resources. Thank you.
Thank you. So now the applicants, Mr. and Mrs. Moore, either one want to go and state anything?
Well, I'd just make a couple of observations here. One of them is, Doug Dennis from Fort Bragg wrote a letter. I think you've got it. Doug Dennis is a excavation contractor out of Fort Bragg. And he started work on this project and on this hill in, I think it was about 1990. And at that time, Paula Dieter was working as a planner out of the Fort Bragg office. And she came down and to see what was going on. And she claimed that we needed to get the county's approval. And she wanted an engineer to be hired to look at what needed to be done to control, if any, possible erosion that would take place. So as a result of that, I hired Robert Huffman, civil engineer from Santa Rosa, to prepare a report for Paula Dieter to approve. And he was to be in contact with Paula about what it is he was going to put in it, make sure to address all of her concerns. And he did prepare the report, and we gave it to Paula Dieter, and she, I think, I didn't, Huffman himself was dealing with Paula there. I told Huffman, your job is to make sure that we get all the concerns addressed and taken care of where the planning department is satisfied. And that's what he did. And he got the approval of Paula Dieter to his plan of what would be done in the way of doing any erosion protection that he thought was necessary. And he prepared the report and gave it to her, and she approved it. And then we went ahead and implemented it. And frankly, Doug Dennis from Fort Bragg was primarily the contractor who was going to do the improvements in that that were in there. And I might point out that there was more going on than just the road. There was a little road work that had been done that they were concerned about, but also, and he wasn't the only one either. There was another guy from Ukiah who was also a licensed contractor, used by the county most of the time. Usually does work for the county. I forgot what his name right now. Do you remember his name?
I don't.
Well, anyway, I've got his report. I can give you his name. He lives right here in Ukiah. He came over and did some work along with Doug Dennis. He did part of the work. Doug Dennis did part of the work. Doug Dennis did about $67,000 worth of the work, and the guy from Ukiah did about $30,000 worth. So there's quite a bit of money there, and What they were doing was some of the things that you're alleging you need a permit for. We were taking ceanothus brush, tick brush, out. You couldn't even use the land for the rangeland zoning that's on it, with all the tick brush that was on the top of the ridge, which is the only part of any stock you would have would only be on top of the ridge there. So it was a reasonable implementation to take out the tick brush. And you might go along and say, well, you need a permit for that. I don't think you do. I think it certainly isn't anything the county enforces. If you've got rangeland zoning and you've got brush growing in the way of where the stock would be, you got a right to take the brush out of the way. And they've been required a permit for that. And as far as the water tanks go, the water tanks don't really disturb very much ground, and it's necessary. It isn't one 30,000 gallon tank. It was 30,000 gallons worth of. We actually have 6 tanks, 6 water tanks, occupying 3 water tank sites. So the water tank storage, when you pump the water out of the tank, out of the well, you've got to put it in the tank. We were permitted the wells, so I don't really understand how putting a water tank requires a different permit than a guy having several wells on his property and having a tank that you pump out of your well into your tank. That doesn't require a special permit that's different from just developing water on your property. So I'm trying to particularly pay attention to these things that you were talking about. Well, there were multiple permits that you needed to get. Another thing that I think is really critical to be aware of is the Coastal Commission when the Coastal LCP for Mendocino County was adopted. At that time, there was a resolution that the Coastal Commission adopted and signed, saying that you don't charge utilities for line extensions. Our proposal at Irish Beach down here was to take the wells and convey them to the district, Irish Beach Water District. They are a public utility. They do have the right to do the line extensions without even getting a coastal permit, and they have the right to put in storage tanks without getting a permit. So that's sort of but I wanted to point out that particular resolution, you can look it up. It was clear back when it was all adopted, and they made an exclusion or exemptions. I mentioned this I went over it with you, Nash, that the permit exemption applies to all utilities. And the exception to that exception is if you are doing it for a residence, you would need to still, you wouldn't be exempt from getting a permit. But if you're not doing it for a residence, you are exempt. And that's in that ordinance. If you look at that ordinance that was adopted back in that period of time, you'll notice if you read through it, that it says that if the project is developing a house, for example, then you're not going to qualify for an exemption because you got to have the house, you need a coastal permit. But if it's not for that, and it's an extension of the utility itself, you don't need a permit. This is the same thing, and it was necessary to be in there, and it was put in there primarily because AT&T, the Pac Bell, City Water Systems, etc., they all wanted to know that they weren't going to have to go out and get a lot of coastal permits to extend their utilities. And the answer is yes, as long as it's not to serve a specific residential project. And yes, you would qualify. And there's a section of it in there I could go over it with you, Julia, if you need to. or if you wanted to, and I can point out the sections of it that I'm referring to. I did point them out to you, Nash, when we were talking. Remember, you were saying that you can't expand the water system. And this is north of Irish Beach. When I say north of Irish Beach, I'm dividing the Irish Beach into south of the creek versus
I
north of the
think
creek.
you're referring to a different area than where the project that we're talking about today is
No,
located, is
no,
that right?
No, not really, because, well, yes, what we were talking about was you were telling me that we needed a coastal permit to have the Irish Beach Water District extend the lines further to the east. And I told you, no, that isn't the case, because the extension of the lines to the further the east were going to be so that you had power to the well, for the well pump and all that kind of thing, and there was no residential application attached to it. So I cited you the section that said that you have to, if there's not a residential project that you're doing, then that qualifies for the exemption. So it all has to do with that initial resolution of the Coastal Commission in creating, and that's the same resolution that the utilities themselves rely on now on the Mendocino coast. I'm talking about Pacific Bell and particularly PG&E and outfits like this. If you're doing a house project, that's different. You can have to have a coastal permit. But if it's not a house project, you qualify for the exemption. And I forgot what section it was anyway. So that's kind of related to some of the things that you were talking about. The other big comment I want to make is just, I don't really understand how we're going to have anything ever happen up there at Irish Beach if we're not going to have a general plan amendment that we got going. I think when I just talked with you, Julia, you were talking about the only place you said.
If I could, let's focus on this item and not a general plan amendment.
Okay.
And
Yeah,
if you could wrap it up now.
Okay, yeah, that's one of the things wasn't clear to me, is whether or not you're thinking that this is separate from processing.
Would you like me to clarify?
Yes, please.
Yeah,
So this item here is really speaking to about the number of separate legal parcels that may be present in this area, which you have the general plan amendment and rezoning application submitted. These are two separate types of entitlements. However, the results of this will inform staff's review of that general plan and rezoning application, because our analysis may differ if we're talking about multiple separate legal parcels receiving an asterisk in designation versus a single legal parcel. And I believe I put that in an email to you as well in the past, that staff was concerned about applying an asterisk designation over multiple separate legal parcels, which could be sold separately over time. But that, again, that's a separate project from the item before the Coastal Permit Administrator today.
that's what I wanted to put. That's
So
what I was asking.
that is still moving forward. That project is moving forward. The results of this are not necessarily going to prevent that project from moving forward through the process, but it is a clarification that needs to occur to support staff's analysis and how we review that project moving forward. Does that make sense?
I can understand that, yeah.
And the CPA would like to stick to the facts associated with this item and not other items today.
Thank you.
Is there anything else?
I think that's the main thing, is that
All right.
the disclosure about whether or not there's fraud or not is the key to the whole case that you've got. Even the justification that you're giving relies on fraud. And as Colin explained to you why there is no fraud, it isn't being received that way by you people here from what you're apparently recommending, but it is nonetheless the case I just want to point out that that's the linchpin, is whether or not it's fraud.
All right. Anybody else from your side that wishes to speak on this matter? If not, then I'm going to go ahead and open up the public hearing on this item. Is there anybody from the public that wishes to speak on this matter? I see Margaret Ballou. Do you have to let them in to speak?
She doesn't own any property on the hill.
You've had your turn.
Okay, just,
This is open public hearing now.
I understand.
Ms. Ballou?
Yes, can you hear me?
Yes. Please identify identify yourself for the record.
No, nothing to put on the record, thank you.
Nothing to put on the record. Okay, thank you very much. So with that, I'm going to bring it back to the Coastal Permit Administrator. And again, we've clarified that the general plan is separate from this.
Correct.
Okay, and when we talk about the revocation, just for clarification, is we've had a couple of boundary line adjustments that have gone through the system that may not have been able to have gone through the system, and that's why staff is here today.
That is correct.
And obviously, you know, in the evidence that I have here, it's noted that, you know, the applicant should have had constructive knowledge of what was going on since they were involved in a litigation years ago. And that information has been presented. I look at it as if there was an issue with processing, you know, I still come back to two wrongs don't make a right. This action would correct what has occurred in the past, is my assumption, by the revocation of the boundary line adjustment. In other words, it did not happen. It should not have happened, is what's being outlined here in the memorandums. You know, I always appreciate the comments of, you know, resources and housing, but we're talking about some boundary line adjustments here. And we're talking about the resources necessary to correct a wrong. And obviously, I've heard all sorts of comments in the past about why this, why that, and why spend time on resources, and that argument just doesn't settle with me. We want to get to the facts, and the facts are that two boundary line adjustments were processed that should never have been processed. And the action that's recommended by staff here is to basically undo that process so that we can return these sites back to what they should have been. I understand from the memo and the documents here that this is not a taking. Property would still be owned by the applicants. And again, when somebody signs a document that says that they have full knowledge or the application, I consider that constructive knowledge. I certify that the information submitted with this application is true and accurate, is what the statement says, and it was signed. So with that, I have reviewed the evidence, the memorandum that was submitted with the original submittal dated September 14th, as well as this memorandum dated November 8th in response to Mr. Morrow's comments. And I will go ahead and move to revoke the two boundary line adjustments, B 2018-0068 and B 2019-054. So with that, those two boundary line adjustments are revoked. And if staff could go ahead and point out the appeal process.
Yes, so I just want to clarify, does your action include the findings specified in attachment D to the memorandum?
Yes, I'm sorry, but yes, it does. So the evidence attached is also the findings of fact dated November 9th, 2023, determination to revoke the approval, which is findings 1 through finding 18.
Yes, so thank you for that clarification. And so under item 18 on the findings of fact, it does specify that this is an appealable action to the Board of Supervisors within 10 calendar days after the date of the decision. There is a form, if you choose to appeal it, with the clerk of the board, as well as a fee that is required for that appeal.
And that's it? Thank you. So with that, we move to matters from staff.
No matters from staff today.
Staff. Okay, clerk, do we have any matters from the public?
I don't think so. I don't see the name there of that gentleman. I don't know who.
So we are
Says
on
Hungry
item number
Moose.
5. Matters from the public. The Coastal Permit Administrator welcomes participation in meetings. This item is limited to matters under the jurisdiction of the Coastal Permit Administrator which are not on the posted agenda and items which have not already been considered by the Coastal Permit Administrator, so no action will be taken. Do we have anybody from the public that wishes to speak under this matter, this item? Seeing none, I'll bring it back to the Coastal Permit Administrator, and I will go ahead and adjourn the meeting at 12:14 p.m.